I was turning to the way in which Mrs Justice Thornton addressed the issues, which is in the core bundle at tab 9 and page 126. My Lord, I'm conscious of the need for me to cover my ground rather quickly. I'll take this succinctly, I hope. Page 126, the appellant challenged on 7 grounds in the High Court, and those are set out, listed on page 126. At the first ground effectively came under the umbrella of necessity, and the second ground is addressed later under human rights. At paragraph 37, Mrs Justice Thornton noted that the argument being put was one for generic protections, as we have seen, and also in the second half of paragraph 37 noted potential for tension between an order that granted a right to discharge effluent, amongst other things, and protections that sought to avoid any injurious affection through discharge of foul water after treatment. She then proceeded to deal with each of the 7 errors, and that is done in her judgment from paragraph 53 and 55 onward, with each error identified in brackets after a subheading. And that led to her conclusion a new point at the High Court. And none of those conclusions is based upon any disavowal of rights that the Canal Company asserted. The judge addressed each of the alleged errors of law and concluded that the inspector had properly exercised his discretion by reference to material considerations. The passage which is criticised under ground 1D is at paragraph 76 of the judgment on page 137, and this paragraph appears under the heading Raising of New Points on Appeal. Mrs Justice Thornton was not misunderstanding that the Canal Company advanced the discharge proviso as a generic basis to reflect the rights it had historically. She makes this point here as an introduction to the specific arguments that were then presented to her at the High Court as to the specific scope of the remedies that may or may not survive and be available to the Canal Company in different future circumstances. And it's those points which related to fine distinctions as between negligence, nuisance, deliberate wrongdoing, that formed part of her dismissal of those arguments as new points, and which the Court of Appeal did not grant permission to appeal upon under ground 2. And the appellant's skeleton argument at footnote 6 accepts the refusal of permission on ground 2 and does not seek to re-argue those finer points of detail as to remedy that arise in particular circumstances. And so this paragraph in my submission had no bearing on the judge's rejection of ground 1 as it was put to her, based on the arguments made by the Canal Company to the inspector. The effect of paragraph 76 recognises the generic approach that had been taken and previously dealt with in the judgment, and holds the Canal Company to that generic approach. It's not saying in any way that the argument for the discharge proviso should be ignored. The judge has thoroughly dealt with that already in her judgment. She's saying that it's clear that the discharge proviso was not sought to be justified by finer points of private law remedy, such as was currently being made to her in the High Court. And so it's my submission that when read fairly, the alleged error in ground 1D doesn't go to the substance of the judge's conclusion as to why the Secretary of State's decision was lawful on public law grounds. I further submit the judge was right to refer to paragraph 253 of the closings in support of her argument that the points being made to her in the High Court were very different to the points that had been made to the inspector. And that is, in my submission, sufficient to deal with the error alleged in ground 1D that's been permitted. But in any event, both the inspector and the judge were very clear as to the scope of the legal arguments being put forward for the discharge proviso. And as the judge shows, and as I have hopefully taken in court too, all of those arguments were based on the wholesale carry-across of the generic provisions from the historic implied rights. And the inspector's conclusion was in effect to the effect that it was inappropriate to carry across wholesale for an express right following the conduct of an inquiry which had carefully considered the consequences of the proposed scheme and how it would be regulated and what the justification for the order as a whole was, which was to deliver a compelling case in the public interest motivated by proper functioning of the sewerage system and environmental improvement. Having made that central submission, if I may turn to 3 points that arise from my learned friend's oral submissions this morning. Firstly, I submit that this court and the High Court is correct on a statutory review to approach the issues on the basis of the argument and evidence that was made to the decision maker. And as such, it is within that argument and the inspector's treatment of it that one must ascertain a public law error, and in my submission there is none. The second submission in response is to draw attention to the fact that the appellant's case as it's put today is inconsistent with the case that was put to the inspector. If I may ask the court to look at my learned friend the appellant's skeleton argument at paragraph 26.2 on page 36. This was addressed earlier by reference to Debatewell. The appellant here trails, and I say trails because it's not put forward as essential to its case, an argument that there may be a limitation on the private right granted, so that it did not grant a right to make discharges of the sort identified by section 1175A, which is a new argument, as my learned friend said, and not one in my submission that the court needs to address. It's inconsistent with the way the case was put to the inspector, which was on the basis that the right granted was effectively unfettered in private law terms. And that was part of the justification for the discharge providers on the case then made. But in any event, if one proceeds on the basis that the right may be limited to compliance with the permit, then that is not an answer as to why the discharge proviso that has been sought should be imposed at all. Because the discharge proviso that is sought does not rest on section 1175A. It also seeks to incorporate those protective provisions in 1175B and 186 that apply a different test as to the effects of the potential discharge on water quality and injurious affection. And so in my submission, if this were right, it would be an argument as to why the imposition of section 1175A were not required. But as it is, it goes nowhere in the scope of an argument which goes well beyond section 1175A and would bite in circumstances potentially where discharges were made in full compliance with the environmental permit. The third and final point in the response, although it's in two parts, I'm afraid, is to address the submission that in some way the imposition of the discharge proviso by the Secretary of State was contrary to the policy of the statute.
You mean the non-imposition of the proviso?
Non-imposition. Yes, forgive me, I do. And in my submission, that's incorrect for the following central reason: that the statute carefully distinguishes between protections for an express grant and protections for an implied historic grant under section 116. If I may go to the provisions to highlight some examples of that distinction within the authorities bundle at tab 3. Section 117.
When you say section, do you mean page?
I mean section 11. I'm so sorry. It's page 99.
Thank you.
Section 117. Subsection 5. The protections in both A and B are applied in the context of specific rights, including section 116, and provide protection specifically within those circumstances. While on this page, I draw attention to 5B, in that the limitation in 5B applies specifically in relation to foul water and ensures two things. Firstly, that it has to be treated before discharge, and secondly, treated so as not to prejudicially affect the purity and quality of the water in the stream. So that's an example of where, for example, a protection in 1175B may go well beyond that in 117A, if one had a permit that authorised the discharge of untreated foul water, for example, then that would not be prohibited by 1175A, but it would be by 115B. And these protections are specifically applied to 116. The other provision that Learned Friend now relies upon, section 186, which is at page 105 of the bundle. 105.
Thank you.
And it's subsection 3 that's in play, is applied specifically in relation, as we saw earlier, to the relevant sewerage provisions, which is again, as set out on page 111 of the bundle under section 219 a very carefully constructed set of provisions. The compensation arises under Schedule 12 in relation to those provisions, and is a specific compensatory scheme for damage up to the limits that are authorised by the relevant sewerage provisions. So those are the protections that apply to implied rights and relevant sewerage provisions. When one comes to express rights and section 115, which is on page 101 of the bundle, there is no restriction on the face of the provision, other than that the right being granted must be required by the undertaker for the purposes of its functions. And section 155 subsection 5 modifies particular provisions of the Compulsory Purchase Act 1965 through Schedule 9. Schedule 9 is set out at, as relevant, page 119, and this modifies section 7 of the Compulsory Purchase Act 1965, which is also, I don't ask you to turn it up, but to note that section is at page 9 of the bundle. Section 7 is fundamentally a compensatory provision that applies in relation to diminution in value of land by severance and injurious affection. And what Schedule 9 does is to modify the particular general provision so that it applies specifically in relation to the right that has been granted. And so the compensation payable under the modified section 7 is in respect of, as the court will see on page 119, is in respect not only of the value of the land over which the right is to be acquired is depreciated, but also to the damage to be sustained by the owner of the land by reason of its severance from other land or injuriously affecting that other land by the exercise of the powers conferred by, in this case, the order. And so there is a clear distinction in that whereas in relation to the implied rights, particularly in relation to the discharge of treated effluent, there are restrictive provisions as to the causation of injurious affection to the water body. In relation to the express grant, there is no restriction, but it is subject to compensatory provisions that will provide for any injurious affection to the land ownership that the right affects. And so it is entirely within, in my submission, the policy of the scheme to grant an express right without any restriction akin to those that apply to the implied right, but subject to the compensatory provisions that compensate for that. And my Lord, in my submission, that is recognised throughout the body of case law to which my learned friend refers, and I hope it's sufficient for present purposes to look at how this point is addressed in the 2024 Supreme Court decision, which is at tab 40 of the authority bundle. Paragraph 1. makes clear that the case concerned discharge of foul water from existing outfalls. This is page 1451, forgive me. Discharge of foul water from the existing outfalls under the historic implied rights. Paragraph 61 on page 1472 draws attention at G, so paragraph 61 at G, referring to section 1175, referring back to section 17 of the 1875 Act, which had been considered in Durand. And the court note it makes clear that the provisions referred to, which include section 116, don't confer any authority to construct or use sewers, etc., for the purpose of conveying foul water into canals or other water courses without adequate treatment. Paragraph 64 is then dealing with section 155 and part 6 of the Act, and it emphasises there, the court, that the powers conferred include powers of compulsory acquisition of rights over land, which could include the right to discharge foul water into a watercourse. And so this recognises that the scope of express rights is wider than implied rights, and necessarily so, because the use of the express rights is the answer to the restrictions that are imposed through the implied rights. If the implied rights are insufficient in relation to a historic outfall, then it will be the compulsory acquisition power under 155 that will be necessary to authorise that right. And that, in my submission, is shown to be entirely consistent with the BWB and Severn Trent case to which my learned friend referred, when one sees at page 1474 of the same judgment, that case is referred to at paragraph 68. The argument being as to whether section 159 carried an implied right to discharge. The Supreme Court endorses the judgment of Lord Justice Chadwick from H. So if I may draw attention to all of paragraphs 70 to 74, but to highlight in particular at paragraph 71, one of the reasons why such a right could not arise under 159 was because it was not a relevant sewerage provision, and so there would be no compensation. And then paragraph 73, the answer to that, the answer to there not being such an implied right, was to use the express right, and that right was subject to a right of compensation, that being Schedule 9, to which I've just taken your lordships and your ladyship.
Can I just ask, you referred to paragraph 64 and the bracket saying which could include the right to discharge foul water. Isn't that a criminal offence?
No. The breach of a permit, if the permit didn't authorise particular discharges, would be a criminal offence, but by itself it would not.
And permits in this case?
Permits have not yet been granted.
And were they addressed in the reports?
Yes, they were addressed both as to what the current situation was, and as I understand it, in the supplementary bundle there is the statement of case at the outset of the proceedings, which drew attention to the motivation for the scheme being in part difficulties that were anticipated in relation to compliance with the existing permits through the discharges at the Salteye Brook. And the, well, so Mr. Strawn will probably be able to provide more detail on this, but at the inquiry there was evidence as to what, a lot of evidence as to the water quality and how that would enable compliance with environmental permits to be fixed in the future. And finally, on that point, as to the distinctions between the statutory schemes, if I may just go back to the 2014 Supreme Court decision, which is at tab 28 of the authorities bundle, page 977. As you've heard, the question in that case, again, it concerned implied rights. And paragraph 17 on page 977 from Lord Sumption notes that new outfalls being brought into use for the first time after 1991 can reasonably be expected to have obtained any necessary consent to discharge onto private property and so on. And Lord Sumption draws attention to the statutory procedures that have to be complied with, the ability to object, and the consequence of an objection being obviously the need for a public inquiry, and therefore for the undertaker, sewerage undertaker, to demonstrate a compelling case in the public interest for the specific new right being sought, which is clearly a significant distinction from the treatment of a right that has arisen historically through operation of section 116. So in my submission, in addition to the primary submissions I made earlier, as to the point not going to the errors of law asserted and as addressed by Mrs Justice Thornton, the distinction within the order and the decision not to apply the discharge proviso as sought is entirely consistent with the policy of the statute. And the inquiry presented the opportunity to both parties to put forward their case as to whether or not it should be imposed, and the inspector's conclusion that it should not. My lords, that are the submissions I want to make on 1D.
Thank you very much.
Take your book. Yeah.
Yes, Ms. Moore.
Thank you. In terms of a route map, what I want to do is very quickly pick up some key facts, then look at briefly at Article 1, Protocol 1, but combined with compensation because it marches hand in hand. Then pick up Dalston projects, then less intrusive means, then looking at MSCC 2024 and the criticisms being made in relation to that, specifically looking at Mrs Justice Thornton's judgment, and then looking at ground 3. In terms of key facts, and I know I need to move really quickly, the court probably has a lot of them. I don't know whether it would be helpful if I summarise the ones that I think are key to the Human Rights Act argument bases. And I've got 10 areas of key facts that are relevant to the Human Rights Act arguments sitting under ground 3 and ground 4. The first one, and you see this in the judgment at judgment 17 to 18, is that the CPO test requires a compelling case in the public interest to be justified. And so that was a view reached on the merits that there was such a compelling case. The second is that the process has independent scrutiny. That comes from the inspector's report at 910 at public inquiry. In this case, that was 29 days, 6 to 8 weeks, because it's a 4-day week in inquiries. That's important for proportionality. Third, core features of the scheme relevant to proportionality. Those are 1, required by the Environment Agency. 2, the overall benefit to water quality is improved. 3, alternatives were explored. This was the preferred option. That's in the inspector's report, in particular at 940 at electronic page 453, but there's a longer discussion.
Sorry, paragraph 940.
The key findings are at 940 of the inspector's report, electronic bundle 453, but there's a discussion about what those alternatives were and how they were looked at. That's at 931 to 934. 4, it will be regulated and operate under a permit. 5, compensation will be paid. 6, the scheme's right is specifically the right to discharge water, soil and effluent. It's a very specific right. It was set out in terms, and you've been taken to that, but you were taken to the front page. The back, the next sections, which are also in landscape, they set out how that right is for the particular parcels of land. That means it includes a right to discharge foul water. My 4th key fact for the proportionality balances, CPOs are bespoke. They can go above, below, be different to provisions in a statutory scheme. And in fact, as has already been explored in questions from my Lord, MSCC originally sought a wider proviso than the one that is being looked at now. And they chose to run their generic argument. They chose not to run a specific argument on specific evidence on why they sought specifically whatever finer provisions they wanted and why. And they could have argued for whatever they wanted. The inspector found on the evidence that it wasn't needed and wasn't reasonable. 5, the independent inspector reached a clear view, compelling. His main reasons are at 910, but they're most conveniently summarised by Mrs Justice Thornton at paragraph 72 of her judgment. It's a 200-page report, and the court has been taken to it, in my submission, somewhat unfairly, given that the water quality case was abandoned. So the inspector set out the arguments as they were standing before the inspector. We focused on one part. I would ask the court to look at the whole of the conclusions when considering the level of scrutiny and analysis that took place in 29 days. And found a compelling case in the public interest, and the key reasons at that are at 938. He carried out a separate human rights analysis. Of course, that is read in the context of the report as a whole. That's beginning at IR 944, EB 453.
Sorry, IR?
The inspector's report 944 is where it starts, electronic bundle 453. Comes near the end after he's done the rest of his conclusions and findings, bringing together those facts. 6, it is confirmed by the Secretary of State. Under the statute, the Secretary of State is the primary decision maker as to whether or not to confirm the scheme. That's section 155. The order, as confirmed, is specific, and the Secretary of State sets out the key reasons, and these are in the core bundle, beginning at EB 478, and as the court may be aware, the decision letters from the Secretary of State attach the inspector's report. It's sent alongside it, so paragraph 1 refers to the inspector's report, and it refers to those conclusions as part of its reasoning. The Secretary of State carried out a Human Rights Act assessment, carried out one on the 3rd of December 2020, that's at EB 480, and following the correspondence, you'll see the two letters, 14th of October 2021, EB 492. 7. Mrs Justice Thornton, in a careful judgment, upheld the quasi-judicial determination that had taken place and carried out her own proportionality assessment. She reaches the clear view that the inspector's judgment was not tainted by legal error. That's at 117. And there's no ground of challenge in this court to the inspector or the Secretary of State. And at 118, she sets out a clear focus why it would undermine the objectives of the CPO and the public interest. And she has a clear focus stepping back, at judgment 119, following to the fair balance and the common ground of the compelling interest, which was accepted. 8. There's actually a further statutory protection for MSCC in this case because it's a statutory undertaker. That means that its land can only be purchased if doing so will not cause serious detriment to the undertaking. And that's at judgment 16 and 26. It's not challenged that it will not.
Sorry, judgment at?
Paragraph 16 of Mrs Justice Thornton's judgment 16 and 26 is setting out the statutory framework. You can find the relevant provision at page 19 of the authorities bundle. It's not challenged. 9, as to the nub of a proportionality issue, well, normally in a fair balance convention case, there's actually specific fact and specific evidence which one side or the other is pointing to say it's compelling for a different decision. And in this case, this difference is frankly all still theoretical. It's really quite hard to pin it down. And it's evolved a little bit this morning. And it appears to be essentially now that while the principle of the CPO is not disputed, nor is it now disputed that compensation will be paid and is capable of compensating, but it's said that they should still have a right, the right that they seek, because that's what implied rights to discharge get. And my lord and my lady, for that, and I will come on to this in more detail, but there is obviously regulatory uncertainty between the concept of injurious affection, just as Mrs Justice Thornton said, and against a clear right and a clear permit. Now, obviously, in particular cases, that can be resolved for fact and degree, but this inspector was looking at a specific CPO in a specific context of a long-fought inquiry against a background of 2 statutory undertakers who have been locked in litigation for some time and reached the set of views that Mrs Justice Thornton is reflecting in her judgment. That is relevant to the proportionality balance. So turning then, if I may, to Article 1, Protocol 1 against that background.
Sorry, did you have 10 points?
Yes, that was that not my 10th?
Well, I had it down as your 9th, but I may have missed it.
My lord is quite right. My 10th was what they were saying on valuation is that there was a risk they'd receive a one-off payment that would either undercompensate or overcompensate for something that may or may not happen. But that has kind of fallen away because my learned friend now says that it doesn't turn on the adequacy of compensation.
Well, he did still say that it's one-off and it would always be future-looking. And what happened if you effectively had a massive spill which polluted the whole of the canal?
Well, my lord, I agree. He went on to say that. And of course, the issue for Article 1, Protocol 1 on the fair balance is that it does march in part with compensation. But of course, the case law doesn't say that you have to get full compensation for everything. And the issue with the valuation is that, and my lord, these are questions that may be best put further to Mr. Strawn because I'm not a compensation expert. But my understanding is that the aim of the scheme is to compensate people as best you can in money's value at that point. And that's what Mrs Justice Thornton says in her judgment. And my understanding is that isn't being disputed. So
Well, the problem is it's complete guesswork as to whether detrimental spillages are going to happen, and if so, how many, over what period, with what consequences. I mean, whether you're the world's leading expert in assessing compensation, you don't know how many spillages there are going to be into the canal from this pipe.
Well, my lord, what the case law talks about on the A1P1 balance is that it should be a reasonable relationship to the right that's being acquired. And there is a scheme in which valuation evidence can be produced. But if I may, I would suggest that detailed questions on compensation, perhaps either Mr. Williams or Mr. Strawn can discuss those, because I am not a compensation expert. But where I can say is what we have in the case law is this clear interrelationship for Article 1, Protocol 1, and for there to be some form of compensation. And probably, my lords, you see this all, and my lady, you see this through the case law from the earliest stages of Sprong and Sweden. You can see the role of compensation. But the most useful case is in SRM at tab 23. Which begins at page 672. For the principles established by the authorities. And at where the sideline is at page 673, paragraph 48, that the requirement of proportionality by no means implies that someone must always be compensated at a full value if a violation of A1P1 is to be avoided. Such a role would frustrate, not fulfil, the search for the fair balance. And so compensation terms, you can see set out there in holy monasteries, are under the relevant legislation and material to the assessment. But what is being looked for is a payment of an amount reasonably related to the value.
And the point here is that Parliament has struck that balance in providing the compensation provisions that are provided for in the statute.
Yes, my lady, that's the primary point. The secondary point, which of course sits within Mrs Justice Thornton's judgment, is also that it was open to the appellant to bring specific valuation evidence if they'd wanted to argue certain particular elements as to the CPO, and they didn't. And it's both of those points together, because compensation is still available at the point at which they enter into the scheme. There is then a process that will assess the appropriate value. And
well, you say it's open to them to bring evidence, and I know you don't necessarily want to answer the question, or let someone else answer it, but I find it very difficult to see what the evidence would be. I mean, I can see that you might construct a model which will tell you that if the canal is completely polluted, then these will be the consequences, and if there's less pollution, then consequences will still be serious, but somewhat less. But I don't see how your model can tell you how often it's going to happen over a given period, or whether it's going to happen at all.
My lord, I think there would be two answers to that. The first is the point that it may be that it ends up being overcompensated or undercompensated. But the second point is that valuation having to value a chance is not that unusual. Whether or not what modelling could do, I would respectfully suggest that you pursue your questions with others. But I would say that it would be entirely possible to produce evidence related to the specific design of this carefully thought out CPO, which has gone through a section of alternatives and been supported by the EA, to look at what it is in the design of the scheme in terms of how it's going to be taking in inflows from where. And it would be perfectly possible to look at how you would model that into risks. Now, how that is translated is a different set of issues as to whether there is compensation, to which there is. And when my learned friend says it does not turn on the adequacy of compensation, because what is not in dispute at all is that there will be compensation. And that's also relevant within the Bank Mellat analysis, which I'm sure the court is very familiar with it, but where my learned friend is focusing his arguments. But it's worth understanding with Bank Mellat, if we could turn it up at tab 26, electronic page E12.
Sorry? Electronic page?
Electronic page 882 and 883.
Oh, thank you.
The key provision that is commonly cited, and which I'm sure the court is very familiar with, is sidelined there at 883. And my learned friend is focusing into whether a less intrusive measure could have been used and whether, having regard to these matters, a fair balance has been struck. My lords and my lady, it's helpful, of course, to see this in its context. If you turn back to the previous paragraph, final paragraph 19, you can see that the question, the essential question being looked at there, is whether the interruption of commercial dealings bore some rational and proportionate relationship to the statutory purpose. And so in this case, the question is there a rational and proportional relationship between making the CPO without the discharge proviso and its purpose, the provision of sewerage services and environmental improvements? And in answering that essential question within Bank Mellat, the court sets out quite a structured approach to reach that overall balance, which is what you see there being set out as the factors in paragraph 19. And that structured approach, is the objective sufficiently important to justify the limitation? Is it rationally connected to the objective? Whether a less intrusive measure could be used? That's how the judge approaches it in her judgment. And it doesn't, of course, mean, as is well known, that the court takes over the function of the decision maker. And whilst we're in Bank Mellat, you can see that at paragraph 21 for the sideline bits. And you can see it further at paragraph 71 in the judgment of Lord Reid. It's not for the court to substitute the assessment for that of the decision maker in that way. And you can also see towards the end of paragraph 20 that these are not absolute questions. These are questions of degree. These are the four requirements are logically separate, but in practice they inevitably overlap because the same facts are likely to be relevant to more than one of them. And you also see the need for that margin to be essential at 883, at D. And going forward to 75 at 903 in the speech of Lord Reid.
Why, looking at 883D, why would including the proviso unacceptably compromise the objective of the CPO?
because it's seeking to be able to discharge foul water in appropriate circumstances in accordance with the permit.
Because it's an objective of the CPO to discharge foul water in some circumstances, is it?
Essentially, yes. The CPO is to cause environmental improvement in relation to a group of overflows and outlets which the Environment Agency wishes to see improved. And so the outcome is moving where the discharges are to a different location with other benefits in a wider scheme. But the CPO itself, the reason why the right was acquired expressly in the terms that was sought, is because that right will encompass discharges that need to fall within all elements of that right from time to time as regulated by an environmental permit. And the reason why the provisos cause, what you could call regulatory uncertainty is because you have a section of protections that have been designed, that are there for implied rights, and that's being contrasted with the express right considered in a scheme. And this is why...
Where do we see, either in the CPO itself or in the material before the inspector, recognition that foul water will be discharged from time to time, and that this is one of the objectives?
Probably the best place is in the conclusions to the inspector's report. So the place that you would most conveniently see the reference under the dispute over the discharge proviso is in paragraph 910, where the inspector is addressing section 1175 and 6 and is explaining the conclusion that the proviso would be unreasonable and unnecessary as the water quality evidence that support it has been abandoned, because the argument was in the impacts of the discharges to the water quality. And if you turn to the statement of case in the supplementary bundle at electronic page 55 and 56.
Well, just before we go there, looking over the page at 913, paragraph 913, under requirement for the order, which I suppose is where you might find the answer to the question I asked, it recognises that there have been sewer flooding incidents in the locality. Where does it go on to say that it is important or a purpose of the order that these should be allowed to happen? I'm not saying it's not there, it's just that I haven't read this as thoroughly as you have. And
Indeed, my lord. You see it in line...
Just to correct, sewer flooding incident is not a permit breach. So
okay. I've misunderstood that.
Sewer flooding incident is an emission from an escape in Marchage terms through a manhole cover or bubbling up through the street. It's not governed by an environmental permit at all. Environmental permits regulate intended points of discharge, and all of the environmental permits in relation to combined sewer overflows, in fact, already authorise, in certain circumstances, the discharge of untreated sewage. The way a combined sewage overflow works is that it says, in a time of storm, in the combined sewer, when the flow volumes reach this level, which is the level at which you've exceeded hydraulic capacity of the sewer, you may discharge the sewage mixed with that high volume of rainwater in those exceptional circumstances. That's what the permits regulate. They regulate what's called flow to full treatment. So the idea that there's some novelty in the permitting system in authorising the discharge of foul water is, with respect, completely wrong.
I'm not talking about that's a miscomprehension of what I was explaining. there is a difference between what can be done under a permit, or there may be a difference in particular cases, between what is properly authorised, regulated, inspected, etc. by the Environment Agency under a permit, and what may or may not be the standard of injurious affection under a consolidating act. What the CPO authorises is the acquisition of the right to discharge soil, water and effluent in circumstances where it was known that from time to time that could include what you might call to be foul water. And that is why there was water quality evidence. The outcome of the 28 days, because it was withdrawn on the 28th day, of the water quality discussion was the acceptance that it causes benefit and there wasn't a water quality issue. So my Lord asked me about the section beginning requirement for the order at 912, and I was about to go to the statement of case. What you see at 912 and following in 914 is that the order scheme was part of the ongoing investment to improve the quality of water courses in the catchment, including the brook. It was the EA's preferred option to divert final effluent discharges to improve the water quality, which it would achieve through the gravity system that reduces the need for pumping, and then sets out the environmental regulation and the possible alternatives that were considered. If my Lord could turn to the supplementary bundle at page 55 and 56. My Lord, there are 2 points that I would take you to in the statement of case that's answering my Lord's question. The key one is at the bottom of page 56, but the step before that, 6.3 on page 55. You'll recall that I said that this scheme was because of the Environment Agency, and you see there at 6.3 that the EA identified serious concerns in relation to 3 sewer overflows, all of which were discharging into Saltire Brook that you see set out there, which were unsatisfactory, referred to at 6.4. And then if you turn over the page, the best place in answer to my Lord's question is, as you can see set out there at footnote 10, that the storm sewage spills will discharge via the new outfall to the canal, and the full scheme will provide for the installation of new powered mechanical screens to screen storm sewage spill discharges. The screenings will be retained within the flow that is then passed forward to the treatment process. The screenings are removed as part of the treatment process and then disposed off-site to a licensed tip. So these are the sort of detailed matters of fact and evidence that the 28 days of the inquiry were looking at in the specific design of a scheme for the specific CPO on the terms that were sought.
Can I just ask you then one point, which is that in relation to the discharges that were looked at, those 3 that you referred to, they have the right to bring a common law action, but under the CPO, they won't now have that right. And I think, as I understand it, Mr. de la Mare's point is, well, that's unfair, and it's not necessary to be part of the scheme that you take away my common law rights.
Well, my Lord, those 3 particular outfalls, as I understand it, will, this may be a question best asked someone who is promoting the scheme, but they won't be operating like that anymore. The whole purpose
I understand,
is to move them and take them away under. So the breaches that might flow from what used to be there won't happen because they won't be there to be flowing from them, if there were any breaches.
But in any event, what the CPO authorises, which is page 497 specifically, and Mr. de la Mare took us to this morning, is a right to discharge water, soil and effluent from the sewers and outfall into the Manchester Ship Canal. So everybody knew that was one of the things that the CPO authorised.
Yes, and the whole purpose was it allowed the public inquiry exploration of the rights and interests and reached the decisions following that process, which included that it was a benefit to the water quality, such that the water quality case was withdrawn. And we've slightly moved from where I was on my speaking note. But what I would say in terms of the case law, when you're looking at this breadth of the CPO and how you balance the interests, and the judge's approach is not criticised. But what you see in the approach to Pascoe and Clay is the importance of factors like, so for example, in Clay, and it's not challenged, so my lords, my lady, we don't need to go there, but for your note, it's at it's the judge's reference is at judgment 108, and the judgment is at tab 18, and at 527. The Court of Appeal said that in that particular case, doing otherwise would be a recipe for poor public administration, for a decision fraught with adverse consequences to have to prevail. And you see a similar discussion about these wider interests in Pascoe at tab 29 at 619E to 621G. And when you draw all of that together in Mrs Justice Thornton's judgment, what you have is that her approach is not criticised. It's at its highest, it's a question of her decision. And we're about to come on to Dalston, but what you see within that is it's clearly a question within category 3 of Dalston for her decision, and whether it's Roman numeral 1 or Roman numeral 2, it's clearly right. In terms of Dalston projects, I don't know if the court needs me to address them on this, given my learned friend's submissions. What I would say on it is that the case is clearly within category 2. And what that means is that we are within the territory of CPR 52.6. And what that means is that the appellate court should not be interfering with the trial judge's conclusions on proportionality unless you decide that the conclusion is wrong. And what explains further in Dalston is that the single question for the appellate court is whether or not it was the wrong decision, and that the focus is on the outcome, not on the decision itself. And Dalston Projects is drawing on Lord Neuberger in Re B, and I'm not sure how much the court would be assisted by me going through it, or whether you would just like the references.
Well, given the time that you've got, if Mr.
Indeed.
Storm's going to have his fair share, you may want to go quite lightly over this.
Indeed,
I
that's
I
why.
don't have a view at the moment as to how decisive it's going to be in the appeal, but you do have, I think, other things you want to cover.
Indeed. My Lord, I would say that in relation to Dalston Projects, the court will be able to read paragraph 29 and onwards of Dalston Project at EP 1409 and see the analysis of Lord Neuberger that is set out there from the case of Re B, and it's clear that the question in this case is whether or not the judge was wrong.
What do you say to Mr. de la Mare's point that she was wrong at paragraph 128?
Well, being the negligence paragraph, my Lord.
Well, no, the proposition
Or
that
paragraph
they
at
can bring a
118.
claim at common law.
The claim at common law. Well, my Lord, I think the key with that, in fact, is to look at the judgment as a whole. So she was clearly applying the law as it stood at the time, and the role of this, and this is where one comes back to Dalston, the role of this is very low in the overall judgment. So if you pick up the judgment, what you can see in it, so if we start at 114, the role of she has set out the framework which is not disputed, including in the context of the CPO, and the role of the court. And then she turns to the application of the legal framework to the facts at 115. And she is addressing the Bank Mellat tests as you go through this judgment. So at 116, She finds the interference is sufficiently important. She finds the inspector's reasons for not including the proviso were in accordance with the law at 117. And then we have her core reasons. We have these at paragraph 118, where she finds that it could undermine the objectives of the CPO. We have the weight she gives to the inspector at 120 to 121. And then we have the theoretical, when she turns to consider the severity of the consequences for MSCC at 122. So this is the part of the judgment in which 128 is falling. And in there, she considers at 123 that the evidence remains theoretical. She then looks at the role of value and compensation, and then she turns to looking at the fact that compensation is a necessary part, that compensation was available. She explores the compensation case that was put, and then she's looking at the case in negligence and nuisance. And, my lord, I say this is where you can see that whatever the decision that comes out of the Supreme Court, the analysis and the core focus of the reasons in terms of why the CPO is proportionate are clearly right. And the role of her conclusion on nuisance is limited. And what she concludes at 129 is that there may be said to be limited value in the protection provided by the discharge proviso. And at 133, she accepts as arguable the difficulty in using the compensation code to arrive at a single capital figure. And she takes all of those factors into account to reach her view at 135.
Well, at 125, she identifies the specific difficulty standing in MSCC's way as the decision of the Court of Appeal in the 2024 case. And we now know that that's not a difficulty standing in their way at all.
My lord, she investigates, she is finding that insofar as a claim in nuisance is, my lord, yes, in simple terms, yes, but you have to see it in the role of the reasoning, which is that at 122, she's turning to the severity of the consequences for MSCC. She's assessing that all of them, in terms of the evidence, that they remain theoretical. And insofar as a claim in nuisance is concerned, my lord, specifically, the water quality case has been accepted. So there is no water quality case from the scheme. And the arguments being run to you are essentially based on the potential possibility of a future claim. So her core conclusion in terms of the severity of the consequences for MSCC at 122 remains that the evidence is theoretical. The arguability of the nuisance and negligence claims, such as they are, and my lord, negligence may well be different.
Well, she says at 129 that the provisos give them limited value because they don't have a tortious claim anyway in nuisance, because that's what the Court of Appeal says.
Well, then she would say no value, my lord. What she says is limited.
No, because there still is a negligence claim possible, but that she thinks is limited value.
And in the context of the evidence which has remained theoretical and that compensation is available.
Right.
And, my lord, where that does in fact then come back to is the question that you're looking at directed to under REBI, Dalston projects and the like, because her key reasons are evidently that compensation is available and the weight that she gives to the purpose of the CPO and the inspector who heard and tested that evidence. So the role of the potential nuisance is just one minor factor of that overall analysis. And my lord, whether or not the proviso would or wouldn't be giving a nuisance action doesn't change that the CPO being sought in this case the breadth of the right is being sought so that it can deliver the environmental benefits of the sewerage function that is in issue. So the availability of the action, which is the property law rights that are being acquired, is cutting across the CPO, for which compensation is available.
There is no question, is there, of United Utilities being able to say, oh, well, if we only get the CPO with the discharge provisos, we're not going to bother. We're going to stick with the existing discharges because the Environmental Agency won't let them do that.
I don't think they have that as a choice, my lord. But
No.
you would need to ask that question to you. My understanding is that they are required by.
I can see if they had that option, then it might be the case that one would say, well, it's important that the benefits identified should be achieved, and therefore, if they might not go ahead, if they're entitled not to go ahead and to stick with the existing discharges, then that would be a reason to say that it was right to have the CPO without the proviso. But if they've got to go ahead one way or the other, and it's only a question whether they do so with the provisos or without them, then that's potentially a different question.
Well, yes, my lord, but the question is actually one step before that, which is that if there is something specific that they're actually seeking to protect in the scheme design, if there is some relevant, important right or interest which would be majorly harmed by a potential set of events, then they could have put evidence of that to the inspector in the inquiry. Instead, they ran a generic argument, which was based on one for the protections given for implied discharges. And my lord, you were taken to the paragraph in the Supreme Court, but it's helpful, I think, to turn to Mrs Justice Thornton's explanation of why the implied and express terms are different in her judgment. Paragraph 55, because what she's explaining in her judgment, page 132 here, is why there is this material distinction between express and implied rights to discharge effluent. Why do they have these different protections in the scheme? Because everybody knew this was a CPO that was seeking the wider right. And as you can see set out there at 57, Lord Sumption explained in MSCC 2014 the reasoning, and that's because the difference between one that has been brought into use impliedly versus one obtained by negotiation or by compulsory purchase in the course of the planning of the works. But if the outfit was already in use at that date, it cannot do this. And the nature of the CPO is to acquire the rights that are necessary for the works that are being planned. And so that is why in the context of this case, in this particular CPO, you have those rights. And my lord, it does come back to the points that Mrs Justice Thornton makes at (118) in terms of how the protections being sought by MSCC undermine, or as she says, could undermine the objectives of the CPO, because they are giving rise to the potential for a conflict on the very face of the order between the right to discharge effluent without the removal of authority for the company to discharge foul water, and the tension between the concepts of injuriously to effect or prejudicially to effect. My lord, I'm conscious of the time, unless, if I just take one more, unless there's any other matter that I can assist you on.
No, thank you very much indeed.
My lord, my lady, I'm conscious I'm coming at the end. I gratefully adopt these submissions on behalf of the Secretary of State, and I will try not to repeat anything they said. I'm afraid I don't have sufficient time. I had proposed to really focus on 3 key fallacies that underpin the appellant's appeal. Unfortunately, that's expanded now to 4. And so I will deal with that in a moment. But just so you know what they are. The first is the fallacy that there's an expectation that the grant of rights by compulsory acquisition for discharges into a watercourse should be subject to the discharge proviso, loosely termed, but those provisos that apply to implied rights of discharge under the statutory scheme. That is a fundamental fallacy which underpins all of the submissions, the expectation or presumption that that should be the case. The second key fallacy, which is linked to that, is a mischaracterization of the CPO scheme and its basic purpose. And the CPO process that necessarily applies to a CPO scheme. The CPO, sorry, I'm using that as an abbreviation, Compulsory Purchase Order, I'm so sorry. But the Compulsory Purchase Order scheme is intended to be a specific response to a drainage or sewerage drainage of a specific area, here Eccles and the conurbation near Manchester, involving discharges into a watercourse through a new pipe where the rationale for those discharges has to be justified in the CPO process, subject to objection, as to whether that is in the public interest, the necessary scheme and the necessary rights acquired. It's completely different from the continuation of pre-1991 outfalls, where no one will necessarily know why or how those discharges came about. Sometimes you will, there may be agreement, in most cases not. Here the CPO scheme is designed, has to be justified, and there's a process for testing the public interest of the balance of interests that are at play. They are environmental, their costs, water quality related to that, as to whether or not it's a good thing to allow, for example, combined storm overflows to occur into the Ship Canal in accordance with a permit. So that's the second key fallacy. And the third key fallacy is in relation to the Inspector and Secretary of State's consideration of the discharge provisos, that they were somehow required or expected to divorce that consideration from the water quality evidence that had been tested extensively at that compulsory purchase order inquiry, and indeed the Ship Canal's case on it abandoned with the acceptance that a discharge should occur and the scheme was not just appropriate, but there was no alternative scheme that was viable. And what I mean by that, just to be clear, is that the combined sewer outflows that occur, the storm overflows that are part of the scheme, were tested not just for their impacts on water quality, but whether there was any alternative that was viable to avoid those overflows, storm overflows occurring. And can I add my fourth fallacy? That it really arises in respect of what the discussion about section 117.5 of the Water Industry Act and what's described as a discharge proviso. It isn't actually a discharge proviso at all. It is a interpretive provision that makes clear that when one is exercising the other rights under the Act, including implied rights, under section 175A, nothing is intended to detract from the need to comply with the environmental permitting regulations as a whole, whereas B is more akin to a discharge proviso, but I'll come to that. But I just want to, I hope, answer quite a few questions that have emerged in consequence of this. It was no part of Manchester Ship Canal's case to seek a discharge proviso, as they call it, limited to 1175A. They were not saying what we're seeking is to ensure that the grant doesn't allow United Utilities to discharge in breach of the criminal law, namely the environmental permitting regulations. To the contrary, and that's never the case they put, to the contrary, they were making the point that 1175 as a whole, both A and B were necessary because it was their case that complying with the environmental permit does not satisfy the freestanding subsection B, prejudicial or injurious affection to water quality, and you needed to have both. And that's precisely what the judge was grappling with in those passages, because what it means, and my learned friend said this in court today, his client will have the ability to bring a claim in trespass or nuisance for this scheme operating, even though it's complying with the environmental permit that has been so thoroughly tested at the examination. This is why he wasn't seeking, his client wasn't seeking 1175A, but they said you've got to have 1175A and B because we want to have the right to you to seek our consent. And just pausing for a moment there, there's nothing more that strikes at the heart of the CPO scheme than that, because it means we then need to obtain the consent in order to operate our scheme, even though we're complying with the permit. If the Ship Canal contends, it's still nonetheless prejudicial to the water quality of the canal or injuriously affecting the water quality of the canal. And they've never suggested, and my learned friend said it again today, it's non-compliance with the permit is not sufficient. They are able to bring a claim if they contend that even though we're complying with what the Environment Agency say is required, they're nonetheless able to bring a claim, potential injunctions, but the scheme itself is therefore under threat. In answer to my Lord's question, what happens if you have the discharge provisos? Depends on what it means, the discharge provisos. 1175A, we've got to comply with the law anyway. If you impose 1175B, we're back to square one.
You say, I suppose, that ex hypothesi, the CPO scheme is there for when you can't get consent.
It's precisely, that's the only reason we're doing it. So we're back to square one in the sense that we're now at the very stage where we started when we were seeking the CPO, namely we can't get the consent of the Ship Canal to allow us to make these discharges. So there's nothing more fundamental than that in relation to it. And the point about that, the reason why this is so inimical to the whole CPO scheme is we spent all of that time testing the water quality impacts of complying with the permit, 1175A, which we don't dispute we'll have to comply with. We did all of that to demonstrate the water quality, not just no harm, but benefits, because, for example, the storm overflows now have screens, there's greater storage, they will still be storm overflows, but now on the basis of this, the provisor goes back in, we have to seek the consent of the very people we are trying to obtain the compulsory acquisition right for. It's a nonsense.
And I'm not sure I'd understood this at the beginning, but I think I do now, that the permits, although they haven't been granted yet, but they typically permit discharge of foul water as a result of storm overflows.
Precisely, my lord. And just to be clear, not an exception. To be clear, that is the current. Well, I say current. That was the position at the time, because even before the scheme, there is a requirement to have the permits to discharge into Salteye Brook. So we already were operating under a permit which did that. The Ship Canal says, well, why not have the implied rights of discharge which apply to those? Yes, they do. The implied rights of discharge are subject to all the uncertainty that you've seen in the litigation as to whether or not that is or is not compliant with the discharge proviso. In circumstances where the Ship Canal would like to say, it doesn't matter you're complying with your permit, you're not complying with the proviso. We've got that great treat awaiting, or that some court does, as to that in relation to existing outfalls. But the notion that you should just simply replicate the position under existing outfalls for this scheme is, of course, ridiculous, because the whole point of this scheme is to acquire the necessary rights based on tested evidence as to water quality, balancing the public interest of allowing storm overflows in that location with specific effects on the canal, as against the possibility of any other alternative, which includes, by the way, we looked at digging up most of Eccles to change the combined sewer outlet flows, which are part of the inherent Victorian system. All of that was explored in the CPO inquiry, i.e., is there a better alternative? Should we dig up more storage, or should we go back to the houses and dig those up and change the sewer system? Is this practical? What are the impacts on the homeowners of doing that, as compared with controlled outlets into the canal in accordance with an Environment Agency permit, for which we were acquiring the very rights to do that? So the discharge proviso is not just unnecessary, but, as we said, unreasonable in light of the water quality evidence that was tested, and then ultimately the Ship Canal abandoned their case. So that's the fourth fallacy.
Sorry, at that stage, just ask you what I understand to be their case, which was fine. That may well be true, and everyone hopes it's going to be better. But with the 3 outfalls going into Salteye Brook,
Yep.
if there's any problems that they have, they can bring a common law action. Whereas now, given the new outfall going straight into the canal, if there are any problems, they can't. And I think they say, rhetorically, how's that fair?
Well, entirely fair, my lord, for this reason. The current arrangements into Salteye Brook, whether or not they can sue us for those, I'm not going to comment, because it raises the question of, if we're complying with the permit, is it truly prejudicial? Is it a breach of the discharge proviso? So I'm not going to get drawn into that for this litigation.
Yes,
but
I don't think we're under any illusion that this is the last chapter in the litigation.
Well, maybe not. I'm ever hopeful, my lord. But in answer to your lordship's question, there is at least, putting it most neutrally, uncertainty in relation to those sorts of issues about existing outfalls. In relation to this solution, which is different, because we're not putting the water into Salteye Brook, we're putting it into the canal, a much bigger water body, where we've tested the consequences of that. And we've been through all the processes, think, is there a better alternative? And it's actually seemed to be better. It's entirely fair that we're allowed to do that compulsorily, because they won't give us the agreement to do it voluntarily. It's entirely fair to take it compulsorily. And of course, that's what the scheme was there to do, to give those compulsory purchase powers, including with the right to compensation. One of the vices identified in the Supreme Court's analysis previously was that if you were going under implied rights to discharge, you then excluded the compensatory rights. I'll come on to the question of what compensation does. But in terms of matters of principle, the statutory scheme is all about, and the leitmotif as it's described in Supreme Court number 2, compensation. Do you have to pay for what you're going to do? We will be paying for this CPO scheme to the Ship Canal compensation for the rights of discharge we're taking. There's a statutory procedure to deal with those compensation claims in the upper tribunal if they're in disputes, at which evidence can be called and tested. where all the sorts of niceties that your lordship was discussing can be explored. I might as well pick up that point about compensation now. The first point is the statutory scheme provides, as a matter of policy, for a compensation code, which has been tested on numerous occasions. Any compensation code, of course, is not a perfect match. It involves valuation in accordance with well-established principles. And, of course, the more speculative the event, the harder it becomes to value it. But that is the very point about the nature of the event. It is speculative to suggest that we are going to breach our permits in order for these events to arise. And that, of course, that's what makes it difficult. But that's why compensation values can do it, make a judgment by reference, for example, to the past events. This is what the judge is referring to. Questions of, is it a likely scenario? Look at the past. Have there been from this particular location with this particular setup a problem? So all of that moves into the arena of the upper tribunal's judgments on compensation. But I've got drawn away from my lordship's question, which was, is it fair? Absolutely. It's what the statute provides. And it is part of the policy of the Act. My learned friend talks about the policy to put implied rights of discharge proviso. Absolutely not. The policy here under Section 155 is to take the necessary rights. You will have to justify doing so. You will have to present your case in the face of objections, which we did receive. And you will then have to call evidence in front of an expert inspector on matters of expertise like water quality, duration, economic considerations. And you would just need to, I don't want to burn the court, but I would invite the lordships and ladyship to read those introductory parts of the inspector's report, including our closing submissions, because we traverse through all of the evidence in summary form that had been given on the vast range of topics. And to give your lordship and ladyship an example, the economic considerations of alternatives were explored extensively because there's an interrelationship, as is known, between what one can do through from a funding perspective in charging customers in order to build more and more infrastructure versus the environmental benefits or gains, depending on what watercourse you're discharging into. There's no absolute principle that says storm overflow shouldn't go into SoS, which your lordship was asking. There's absolutely no such principle. It's a question of ensuring that if that and when it happens, it's occurring in a regulated way, including with the dilution effect of water for storm flows. But there's a judgment to be made for a specific area, for a specific scheme, as to whether it's justified in the circumstances. And that's precisely what this scheme did. Can I just pick up on those four fallacies just in turn? The first was the assumption that compulsory purchase is subject to or should be, there's some sort of ongoing presumption of implied rights to discharge. And of course, I just need to, that's surprising in a sense, because replicating the current situation immediately takes one into the realms of litigation over what these rights of discharge mean, which is, of course, what the CPA scheme is designed to avoid. But it's also, in my submission, not the correct analysis when one looks at the purpose of the compulsory purchase process. And I can probably just illustrate this simply by taking you to the Ship Canal's statement of case in the supplementary bundle when the scheme was first proposed, and under the statutory processes, the promoter has to produce their statement of case and objectors produce their statement of case, as effectively pleadings. And the claimant, as they weren't then, but the Ship Canal statement of case is on page 102 of the supplementary bundle. And just to understand what I mean by the ability to object to the specific scheme and its impacts, there's a summary of their objection at paragraph 1.4, page 106. And I invite the court just to look at it. I'm not going to read them all out. But the Ship Canal's objection in principle to this scheme was in fact based on the proposition that the existing arrangements into Saltide Brook, in accordance with permits, was not acceptable. So the very issue my lords just put to me about, well, they're complaining about the existing arrangement. Litigation may or may not happen about that, I don't know. But here, this scheme is to try and change that arrangement, but then get the necessary rights to deliver it. These are not cheap schemes. You have to build tunnel. If it's really being suggested that we're embarking on a project where we still haven't got the consent to actually use the tunnel at the end of the day because there's an ongoing argument about the discharge provisos, it creates a highly precarious situation, or the prospect of building it and then suffering from an injunction to say, well, you can't put the very overflows that you designed it to take, despite having satisfied all of these objections. There's a long list under 1.4 of all of the objections in principle, ranging from sustainability, alternatives, creating more storm overflows into the same location. And I hope this answers my Lord or Justice Mayall's question as to whether it was known that there's going to be storm overflows. Of course, that was one of the one of the premises of the case which was being explored. And you can see that from, say, 4.1. They were saying this scheme would entrench an existing arrangement, namely storm overflows, etc., and final effluent going into the canal. Now, I could take. I haven't got time. I could take the court to the detail of that statement case, but it then led to, as you'd expect, a whole series of witnesses being called on water quality, the impacts of the scheme, the complaint about the design of it, whether it was going to cause sludge, etc., and the promoter then having to call contrary evidence. There was a whole section of evidence on alternatives, as I've identified. Is there a better solution which should be provided? And there was a whole section of evidence on the financial or fiscal implications for taxpayers or ratepayers of alternatives. All of that goes to the principle of the scheme, and the scheme being one which involves discharge of stormwater into the canal. So there's the objection. When we talk about, as we do in the closing submissions to the inspector, how is it that they are seeking to impose the discharge proviso divorced from the water quality evidence? We said they're washing their hands of it. In circumstances where they're no longer pursuing any of these points of objection of principle, they say they can. We said, no, of course you can't, because the whole purpose of the scheme is to deliver storm overflows, amongst other things. We've tested all the water quality. You can't suddenly then argue for a discharge proviso, which puts that very matter back at large when it comes to the question of consent. I.e., we build our scheme, we're then told the Ship Canal objects because although you're complying with your permit, they think it's prejudicial to the purity of the water, or they think it's injuriously affecting the water quality. We'd be immediately back into the very circular scenario, notwithstanding that we've tested all the evidence through this process to say, well, that's not a problem. We'd be back into the very scenario that we were seeking to avoid in the first place. So, in the relation to the law under the Water Industry Act, for the reasons you were taking to some of the passages in the Supreme Court judgment, we say it's fundamental that all of that case law is distinguishing between implied rights to discharge and compulsory acquisition, where the implied rights to discharge are of a very different nature. And in summary, and you can get this from British Waterways Board, Supreme Court number 1 in Manchester Ship Canal, and Supreme Court number 2, the points that are being made consistently in the question as to implied rights to discharge is, first of all, you don't imply a right which interferes with property unless it's necessary to do so. And it's not necessary to do so where the Water Industry Act gives an undertaker a compulsory acquisition power which they will have to exercise if they want an actual right to discharge. So the fact of compulsory acquisition is a very strong reason to restrict the nature of any implied right. My learned friend's trying to turn it on its head by saying because implied rights are restricted, they don't have to be implied into the compulsory acquisition right. That's just reversing the whole basis upon which this operates. The second principle that emerges from those cases is, of course, that the implied rights not only have to be necessary, but it would be unusual, indeed contrary to the leitmotif, for those implied rights to arise without compensation. And the difficulty with the implied rights for outfalls from a pre-existing arrangement is that they don't give rise to a right of compensation in relation to the discharge of any consequences. And so the Supreme Court and British Waterways Board, particularly Lord Justice Chadwick, in that fifth reason you were taking to, identifies compulsory acquisition and compensation as being the very thing that restricts your ability to insert implied rights into a pre-existing situation. And so if you take those principles, of course, the very opposite result from the statutory purpose is achieved. Section 155 of the Water Industry Act is a specific power, has to be authorised by the Secretary of State to acquire rights compulsorily. It's not limited in terms of the nature of the rights. And as I think it was Lord Sumption identified in that bracketed part that my learned friend took you to, includes the right to discharge foul water. And I hope I've addressed you enough on that. That includes storm overflows, for example. And where that right is granted, it will have to go through the inquiry process where there's objection. See what Lord Sumption said about you can't do it overnight. Well, bearing in mind we promoted this order in 2017, I think that was a mild understatement as to how long it takes to acquire these rights. But even through the compulsory stage, what he's alluding to is the inquiry process, the testing of evidence, where, of course, one of the tests is there a compelling case in the public interest for giving you the right to do what you want if someone else is not going to give it to you by agreement. So that, in my submission, clearly all of the case law is distinguishing between the two. And that first fallacy that runs through all of my learned friends' submissions, which is to say, well, why not just give them what they've got already? Well, all the other outfalls currently operate on implied rights. That's because this problem has only really come to light as a result of the Supreme Court litigation, the resolution of the fact that the implied rights to discharge to pre-1991 outfalls are limited by the discharge provisos. And now if you want to build a new sewer or regularise an existing sewer in terms of putting foul water, you're going to have to acquire the rights compulsorily, but that's what the scheme provides. You will pay compensation accordingly.
You said this has all taken a long time, since 2017. Has anybody actually put a spade in the ground yet?
No. Oh, well, just to be clear, there's the CPO scheme and there's a full scheme. Those parts of the full scheme that could be delivered on United Utilities' own land, which involves some chambers and pipe work and non-controversial areas, I think have been constructed. But the CPO scheme is across, that takes the pipe across other parcels of land, and of course has the right to discharge. That hasn't.
Yes, I see.
Because the CPO technically is still subject to the challenge. Well, it's not technically, it is. It's actually subject to challenge.
Yes.
But your lordship asked me about, well, you didn't ask me, you asked the question. Well, why not just put you didn't put it quite like this way, but surely if you has these provisos attached, they'll just go ahead anyway, they haven't got any choice. Well, it's not as simple as that, because if it's more than 1175A, which we've got to comply with anyway, we've then faced the question, can we ever use this? And how long will it take before we could ever use it? Because the Ship Canal is saying it's not sufficient to comply with the environmental permit. Who's then, well, we have to go off to another tribunal to hear the water quality evidence on that.
You mentioned practicalities. Can I just ask, I mean, there's an extraordinary amount of litigation between UU and MSC. Has anyone ever mediated? I mean, you're all public bodies.
I know the answer to that question, my lord, but I don't know whether I'm allowed to.
All right, fine.
Say,
All right. Well, we wanted to raise the point, but if you've already been well aware of it, and we don't need to know further, I think.
Well, yes, I can obviously say that one would expect both parties to be aware of that principle.
Yes.
More than that, I don't think I can.
No. All right.
But I'm very much. But what I would very much like to make clear to the court, going back to the fallacies point, is that come what may about litigation about pre-existing rights, implied rights to discharge, the whole purpose of a compulsory purchase order, the first of its kind, was to secure rights free of that debate. Not free of charge, I have to emphasize, because compensation is payable, and not free of interrogation of the merits of the scheme. To the contrary, we went through all of that evidence. But we went through the statutory scheme in the context of avoiding that. And that is why it's so unfair to criticise Mrs Justice Thornton's points in her judgment, where she was tackling the claimant at the time, to say, well, what is it that you're going to do with the discharge proviso in terms of prejudicial effects in juris affection? How's that going to be resolved? And does that create that uncertainty in terms of proportionality, contrary to good administration? And she was entirely, in my submission, on point. The proportionality of removing the right to argue about all of that in the area of uncertainty, to allow this scheme to actually proceed where it's considered beneficial in the public interest, is paramount in my submission. But certainly, she can't be criticised for striking the proportionality balance in that way. And picking up my learned friend's submission, you can see that with paragraph 135 of her judgment. The discussion about, because my Lord Justice Mills raised the issue about, well, she was applying the Court of Appeal in Manchester Ship Canal number 2. Yes, of course she was. But in fact, her conclusions at paragraph 135 on proportionality are actually directed at the point about the proportionality of removing the debates, all of these debates, from this arena in circumstances where the case has been fully and properly tested by reference to water quality. My Lords, I'm going to run out, well, I have run out of time, but can I just give you a few other references? Mm-hmm. In the Supreme Court's number 2 judgment, the latest judgment, that of course again was nothing to do with compulsory acquisition of rights. It's all about deciding who could enforce implied the common law actions in relation to implied rights of discharge. And to the contrary, if you look at it, the references I wanted you to pick up was paragraph 20, Lord Blackburn in Metropolitan Asylum District in Hill, paragraph 33, with Mr Justice Blackburn then, on the relevance of compensation, paragraph 50, subparagraphs 4 and 7, the leitmotif about being compensation, in distinction to what was being argued there, that you didn't have a right to compensation, but nonetheless your common law rights were being removed. All of that's of a piece that, yes, it's wrong to remove common law rights as an interference of property without compensation in most cases, although it can be done in most cases. But that's precisely what's not being done by compulsory acquisition in this case, because the compensation provisions follow. And then the other paragraphs 110 to 120, of course, one of the submissions made by Mr. Dingemans in the Supreme Court was how surprising it would be that the common law rights had been removed without compensation. A proper scheme would be one that did remove rights with compensation, to which I say, precisely, that's exactly the scheme we're operating under paragraph section 155, which the inspector was testing. As to the CPO scheme and what it's about, can I just refer the court to our statement of case? Because your lordship asked about this question of discharge of storm flows. It's set out in detail at supplementary bundle 41. Not only does it cover the storm overflows, but it also sets out the whole statement of case as to why the scheme is being required. Page 41.
Yeah.
And it's extensive, but it covers, if you look at 1.19, you can see how extensive the areas that are covered. And within that, you'll see Section 6 was the need for the full scheme, Section 7, alternatives to the CPO scheme, need and justification for the CPO powers. There's an extensive summary of the case, which was then followed up by the evidence. And that's why I mentioned alternatives, because we did look at whether there was a better solution. And in response to objections, page 79, this is only a sort of summary at this stage, but you can see that objections initially received to the same case were addressed in turn. And you can see the appeal objection, the appeal group, that's the Manchester Ship Canal, page 79. They had set out grounds of objection, we'd set out initial responses, and you can see at the bottom of the last paragraph, in the possibility of discharges in brief doesn't preclude the making of the order. Those implied provisions don't apply to section 155. They're not subject over the page to the limitation. That's sufficient to dispose of the point. And then at the bottom of page 80, discharges from wastewater treatment works and storm water storage tanks have been heavily diluted. We say it would be absurd if that had meant that we couldn't discharge. But we then say at the bottom, if that is wrong, that only strengthens the first point made above. I.e., if we're wrong and these are prejudicial, that strengthens the need for the compulsory acquisition in order to, because we won't be able to do the very thing the scheme is seeking to do. I'm going to have to finish, but I would draw your attention before I sit down on the CPO scheme case, which was then considered by the inspector in his report. He deals with water quality separately from those paragraphs where he's dealing with the discharge proviso. But as the court will be well aware, these decisions have to be read as a whole. And in paragraph 910, he's referring to a summary of our reasons for objecting to the discharge proviso. My learned friend left this out when he cited it. We made the point about water quality and abandonment of evidence, and the inspector said that was convincing and gave the references back to our submissions, which in turn refer back to our submissions on the water quality. So it's completely wrong to suggest that we've offered no reason to why the discharge proviso shouldn't be imposed, or why it somehow it conflicts with the scheme. Our whole case was predicated on saying you can't abandon the water quality evidence because that is what justifies the scheme without the discharge proviso, which would otherwise be hampered. Yeah. Well, I'm going to have to stop there. I no doubt have many other things to say, but unless I can assist you, I'm just going to, so sorry. The discharge proviso 1175 that's been sought, I've already made the point, never sought as on its own. You can see that from the closing submissions of my learned friends. It would also be inapposite to impose 1175A as a discharge proviso because that's requiring one to comply with the environmental permitting regulations as a whole, not the environmental permit. You can see the difficulties that arise because environmental regulations contain all sorts of obligations as do permits. And it would clearly be absurd to say there's a trespass merely because, for example, someone wasn't keeping records or monitoring something in the way that the regulations require. So even as now advanced, the issue, the discharge proviso that's being proposed is not legally coherent. My lady, unless I can assist you further.
Thank you very much. Mr. Lemay.
Yes, I should start with dealing with that point about water quality evidence, because it is actually forensically material to all of this that UU's initial position was that it accepted that the provisos should be applied. And you can see that from the supplementary bundle at page 18 in a letter just above the foot of the heading Impact of UU Scheme. There's a passage that starts, page 18 of the supplementary bundle, the right to discharge sought by UU as part of the order will be subject to the same statutory limitations on UUWL's existing statutory right to discharge as are contained within the provisos. And it's 1175, presumably A and B, and 1863, which is the two provisions that we're relying upon. Accordingly, we do not accept that the confirmation of the order by the Secretary of State would be inappropriate in any way, and nor do we accept that any such confirmation would affect the legality of the discharges. And it's that position that UU effectively themselves resile from, and that really falls to be explained. It's that requires justification. You'll note there's no trace of any suggestion at that juncture, with those concessions made, that the scheme would be unworkable. And that goes to my learned friend's, Mr. Strawn's, first supposed fallacy, which is it's a fallacy to carry over the limitations that apply to general powers, be they express or implied, when you're going through the compulsory purchase process. He says that's a fallacious approach. Well, first of all, we've seen that that was his client's initial approach. Secondly, we've seen under the terms of the CPO...
It's rather a pity your clients didn't respond by saying, thank you
yes.
very much, we've got a deal.
Well, touche, my lord. The second reason it's a fallacy is, of course, because that is the default approach. As I showed you, the first thing this morning, no one's addressed this. The default approach under the actual CPO is to carry over the limitations in relation to all the other forms of easement, with the exception of the right to discharge. So you saw in the General Proviso 4 that the sorts of protections that are present in Section 165 and Schedule 12 were carried over for the rights to enter land and prejudicial effects, and etc. What's never been explained or justified is why that carryover approach should not apply. And of course it's true that Section 155, properly construed, does not require them to be carried over. There's no obligation to do so in all circumstances. And it's also true, as the Supreme Court said in that bracket upon which so much forensic weight is applied, that Section 155 may authorise the compulsory purchase of an easement entitling one to discharge foul water. That really doesn't take you very far. Firstly, the comment is obviously obiter, because there was absolutely no argument about any of that. But secondly, it doesn't begin to do what my learned friends say it needs to do, which is to say, to discharge foul water even if it's in breach of an environmental permit, or even if it is such as to cause injurious affection. And it would be very strange if it said that, not least because under the current scheme of the Act and under all of the implied licences up to 1991, foul water can be discharged. There are two conditions that have to be met in order for that to happen. Condition one, this is as a matter of private law, that the environmental permit is complied with. And the environmental permits, as I, forgive me, jumped up to point out, already authorise the discharge of foul water from certain types of outfalls. They do so effectively for the CSOs and the emergency type outfalls, and they do so in circumstances where the sewage in the combined sewer is diluted by a very high level of rain, such that the sewage treatment works can't handle the volume of water going into the system, but the sewage is diluted. And 3 out of the 4 discharge points that were to be consolidated by this scheme, you can see this from page 298, paragraph 298 of the inspector's report, which details the 4 permits in question. 3 out of the 4 relate to either a CSO or the emergency storm tank overflow or the sewage tank overflow. They are effectively ones that will operate intermittently in periods of high rain with environmental permit conditions that limit the volumes of water at which that's permitted to occasion and require it to happen when rainfall is occurring. So that's the first point. The 4th discharge point is the treated sewage effluent, which occurs when the sewage treatment works is working to its full capacity. And if it's helpful to understand all of that, it's all comprehensively explained on the basis of Mr. Hazlitt's evidence from UU in the judgment of Lord Justice Newgee in Manchester Ship Canal number 2. There's a very clear description of how the different types of overflows and outfalls actually operate. So foul water is already authorised to be discharged by the permits, subject to the conditions set out. That's the first condition. And the second condition, and this is the bar and biffer point that I mentioned, it still has to be the case that that discharge doesn't cause a nuisance, because the foundational rule in this sector, in this area, is that the statutory scheme, even if complied with, does not authorise a nuisance. That's the bar and biffer rule. So it was to nothing that Biffer Waste Services were complying with the requirements about stinky landfills, if nevertheless the stinky landfill was creating a nuisance to the people adjacent to the stinky landfill. Those are the conditions, and it's completely consistent with that to say that there's a compulsory purchase power that allows you in certain circumstances to authorise the discharge of foul water. And that's particularly so when you remember under BWB that what the United Utilities required was consent even for the discharge of clean water. Because absent the easement, any discharge of water into the canal would be trespass. So the purpose of obtaining the easement was to make lawful the discharge of all types of things which wouldn't necessarily even be nuisance. It would constitute a defence otherwise to a claim in trespass. No one's arguing about that. The argument is confined solely in relation to the proviso. And we say, just as with the general proviso for the provisions that regulated the implied powers that the Court of Appeal and the Supreme Court in BWB and MSC number 1 thought were necessary in order for there to be any basis to find an implied power, they are the default guardrails that should operate in this area, absent some very good reason why they should not. And that is not a fallacy, that is perfectly principled reasoning. So then we come to what Mr. Williams said. And Mr. Williams basically accepted that effectively one of the intended purposes of the width of private law grant in this case was effectively to confer immunity even in relation to permit breach. And Mr. Strawn's response to that was, well, you've never made a case focused only on Article 1175A, you're pointing to 1175B, and that has wider effects. You're pointing to 1863, that has wider effects. And so that's the case we should focus on. And as to that, I say two things. First of all, the fact that the case in question has the effect of immunising that which would otherwise be a permanent breach or a criminal offence. In other words, so contrary to the regulatory scheme in question that it's criminalised, is the high point of my argument that none of this has been properly looked at through the lens of justification, the lens of the least restrictive means, the lens of statutory purpose, and the fair balance. And I readily accept that if I fail in relation to the criminal offence point, I'm probably not going to succeed in relation to the wider provisos, but it's a very useful way to test the argument. And the answer produced is that it is contended that it is consistent with the statutory regime to provide an immunity even in the case of permit breach.
But
nothing...
Sorry to interrupt. You don't accept that, though, do you?
I don't accept that that could ever be...
No, because of the authority you showed us.
Well, first of all, because of that. But secondly, my primary answer when you get to A1P1 is that that could never be a least restrictive means pursuing the legitimate aims under the Act. It could never be justified as some kind of rational and reasonable least restrictive means pursuing the policy of the legislation in question.
Are we being required to decide whether or not a discharge would, which was not authorised by the permits, would be criminal?
Well, it plainly is. It plainly is. There's a specific offence. I showed you it this morning. No one suggested it doesn't apply. If you breach a condition in the permit, so you discharge untreated sewage, let's say when there is no rain, that would be a permit breach. If you discharged it when the flow to full treatment condition authorising discharge hadn't been met, that would be a permit breach. If you discharged it deliberately, because you're acting fraudulently, a la investigations into water companies, that would be a permit breach. They would all be criminal offences. There's no scope for any argument about that at all. And they're serious criminal offences. They're criminal offences that sound in 5 years maximum imprisonment. And I don't need to say the extent of the public controversy surrounding this issue. These are important public interest offences. And the argument made is effectively one for an unlimited private law easement that confers immunity even in that circumstance. So that's my first answer. My second answer is, if you think our case is good in relation to 1175A, but not in relation to B, or not in relation to 1863, then that is going to be material when you come to the least restrictive means and test the parts of the proviso that we've put forward that are in fact required. So we say the optic of the criminal offence is a very useful way to test the strength of the evidence, the strength of the reasoning, both of the inspector, the Secretary of State and the judge, and you will find nowhere any reasoning that begins to explain why a consequence quite that wide and quite that severe is justified, beyond the passages in the judgment which basically say, first of all, uncertainty, which I showed you. Second of all, risk of undermining the statutory regime and conflict and litigation. And thirdly, compensation. Those are the only reasons that have been advanced. And as regards uncertainty, here Miss Blackmore's submissions, with respect to her, were entirely contradictory. Because on the one hand, she'll have you believe that the phrases injurious affection or prejudicial affection are so uncertain and so generative of litigation that there's a good reason to exclude any continuation of the provisos to avoid further litigation between our clients, which we don't say is a proper purpose in terms of the scheme and in section 155. But on the other hand, she draws upon the fact that the very same phrase, as does Mr. Strawn, appears in paragraph 7, as inserted by Schedule 9, paragraph 3, as the basis for compensation. So we have the same concept being so vague and uncertain that it shouldn't be incorporated in the provisos, according to the Secretary of State, and yet it to be the basis of any assessment of compensation going forward such that we receive fair compensation. And it can't be both. And the point really resolves to this. How, when you step back and look at the substance, how can it be proportionate if they wish to rely upon the compensation provisions in that way to effectively draw upon this allegedly uncertain term as to an event which is going to have to be assessed through prediction? How often are there going to be spills? How bad? How frequently? Where? Etc. And to, instead of waiting to see if they actually happen and then allowing us to recover the damage that in fact occurs when that in fact happens, as assessed by the court, in line with the assessment that will be conducted in every other single overflow permit, some kind of speculative exercise is to be conducted in advance as to whether or not such events will occur. And if they wish to rely upon the compensation provisions as providing effectively their shield in those circumstances, they have to explain how it can fairly operate in that way. And it's a particular problem because the only way the valuation case is going to be able to investigate that is by looking at the past record of compliance of UU, all the permit breaches that may have occurred over the last 5, 10 years, etc., the planning for how much extra capacity they're building, all the stuff in PR24, all the submission to Ofwat, and then make some kind of predictive judgment, incredibly expensive exercise, as to what's going to happen in the future, instead of simply saying, well, the risk's on you. If it pans out like you said to the inspector, this won't be a problem. The water quality won't be prejudicially affected. You won't breach your permits. Everything's going to be fine. That's the case on the basis of which you've got the CPO, the water quality evidence case. If you're wrong on that, you should bear the risk, and you bear the risk by reference to the provisos, just as happens with every single other proviso in every single other right of discharge around the country.
I think the point, not at least as I understood Mr. Strawn, is not so much that they will breach their permits, but that they will commit nuisances permitted by their permits, because storm overflows is something that the system is designed to...
well, no water company in the land is going to accept that the operation of a storm overflow is necessarily a nuisance.
Well,
it's just the standard answer to that is no. The sewage is so diluted by the excessive volumes of water in question, and it's discharged during periods of late rain that it's already sufficiently dilute that it doesn't constitute a nuisance. That will be the terrain for battle.
Well, I just make
well, it will.
Of course.
And you'll say the opposite.
Well, I haven't said it's a nuisance. The submission I made is that it will be alleged to be a nuisance. Yes. And then we're into
I expressed it loosely. This is going to happen, and then there will be a dispute about whether it's a nuisance or not.
It may happen. It may happen. I readily accept that. But then you really get down to the real justification for the removal of the provisos being to remove, as the judge found, the exposure of the company to that risk of litigation which would occur in other circumstances. And the question that then has to be answered is why should they have that immunity? Why should they have that facility to commit a nuisance in circumstances where their case to the inspector is that the water quality won't constitute a nuisance? Okay. That's the basic problem. So put them to their risk is the answer.
Mr. Strachan, as I understood it, was saying, yes, you're right, and the reason for that is because we've gone through this whole process. There's already been a judgment and a weighing of the public interest. You'll have compensation. Fine, it's not common law rights, but it is a principled way forward. Why do you say that's insufficient?
Well, you can't simply point to the process as a justification for the outcome. Not least because all the case law confirms that what is important is not the process, it's the outcome. That's, respondents have actually been fighting time and time again to stop process points being deployed and said, actually, all that matters is the results. And yet here we have respondents defending the case by reference to the process rather than the actual outputs. That's the first problem. The second problem is that on any view, the judgment is flawed by some absolutely critical errors. And it's here that Miss Blackmore got into, with respect to her, very real difficulty. My Lord Justice Dingemans put it to her, how is paragraph 128 justifiable? And her response was, first of all, to take you through all of the recital of the case law that preceded paragraph 128. And at that point, my Lord Justice Mayles put it to her, well, that was obviously wrong. And she accepted that. She accepted that the statement of the law on which the judgment proceeded was wrong, because it's been overtaken, declaratory theory, etc., by the Supreme Court. And then Miss Blackmore went to paragraph 129 and everything that followed, and at no stage did she actually address paragraph 128. And the problem with that is that paragraph 128 betrays the most fundamental and most basic error. And the basic error is that the judge did not appreciate that without the provisos incorporated, there would be no protection at all of the kind, even as contemplated on the narrow and reduced theory of law in Manchester Ship Canal number 2 in the Court of Appeal. So she didn't appreciate that once you granted an unconditional easement, there would be no facility to sue for anything at all. And that is a basic error that unlocks everything. That, combined with the change in the law, is fatal. And what we didn't hear from any of my learned friends was any attempt to suggest anything other than that Marchich and its dual regulation fears and its hegemonical status for the regulatory system over private law rights. That whole mode of thinking has been reversed by the Supreme Court, which basically, a bit like arbitration and litigation, says that they're separate things doing separate things of equal value. And to that end, it's no available answer to say, effectively, your private law rights are ousted or excluded, the statutory rights, statutory regime trumps everything. That thinking is bad, and yet that thinking obviously infects the inspector's decision, as I've shown you, paragraph 8 of the Secretary of State's decision, and the judge's judgment, and all the stuff about how they'll interfere with each other, etc. It interferes with it generally by reference to damages, specifically by reference to injunctions. All of that analysis is bad of the Manchester Ship Canal number 2. There is no necessary interference. There is no realistic spectre of some kind of unwarranted automatic injunction closing down these operations. And again, look at it from the perspective of perverse incentives. If you confer an immunity, what incentive will there ever be to you, once it's paid whatever sum it pays under the compensation, forward-looking for the right to discharge whatever effluent it wishes to do anything that mitigates the impacts on Manchester Ship Canal of its activities, unless perhaps it can be substantiated that that activity breaches the relevant permits. There will be no negligence-based controls, no deliberate wrongdoing-based controls, no incentives at all. And you step back and you say...
Well, it'll be a matter for the Environment Agency whether to introduce more stringent requirements in accordance with the outcome of any public or political debate that you've referred to.
And so the practical result is that our private law rights are being reduced to enforcement only through the statutory enforcement mechanisms, which don't provide for automatic entitlements for us to sue or to be compensated, that they're discretionary. They're dependent upon the Environment Agency being resourced, willing and able to proceed. That is, in effect, contrary to Barr and Biffa and the Supreme Court in MSC number 2, which says the party should be entitled to protect their property rights against this type of invasion, absent some good reason, and none has been provided. Now, at that point, I fear I begin to risk repeating myself.
Well, don't do that.
Sorry?
I said, don't do that.
No. Or, I thought you were going to say, at that point. I should probably...
I take it you can conclude what you need to say within a few minutes.
I certainly can. I mean, this case, though, I do have a lot of sympathy for my learned friends. Both Mr. Karras and I ran out of time in the 2 days we had in the Supreme Court. I mean, there is a great deal of dense run-up to the essential points. The other fallacies that my learned friend identified but didn't really develop. The second fallacy was a supposed misunderstanding of the CPO process and its requirements to investigate specific concerns. There's no such misunderstanding. We fully accept that once the water quality case was accepted, there's no case then for specific protections. The whole point about our argument in relation to the provisos is that it is in effect long stop protection if everything doesn't pan out as planned. And that's the long stop protection that's removed, and it's the removal of that long stop protection that has to be justified. And as for the third fallacy, that's wrong because it doesn't reflect the fact that the UU case was predicated on the water quality case coming to fruition and compliance with environmental permits. They weren't running a case saying, well, whatever environmental permits are applied, we're going to be breaching them, but because we're going to be breaching them, we need protection. You'll not see that in any of the evidence or any of the reasoning. And then I dealt with the fourth fallacy about section 115A and that the case was put on that basis alone. It wasn't, but it's a forensically useful point on which to test it. I should also deal with my learned friend's point that we're back to square one, and the fact that the provisos will expose UU to potential litigation in certain circumstances undoes the whole CPO process. That is, with respect, completely untenable. And what it actually reveals is that UU's objective by seeking to remove the provisos is in fact to obtain an immunity from exposure to a claim in damages, whatever it does as a matter of private law. It's not back to square one because square one is BWB, and square one is that there is no power at all to discharge anything into the canal, whether it's clean water or foul water, absent consent or statutory compulsory purchase. And the compulsory purchase, in fact, provides UU with everything that it needs to conduct an operation entirely equivalent to the operation it's currently conducting with discharge at the 4 points that go into the Saltire Brook. So to say that it undoes all of the benefits of the compulsory purchase is, I'm afraid, high-blown rhetoric that has no substance. I think that's probably the totality of what I had to say and what you would bear with me. It's late hour on a Thursday before the bank holiday, but if you just forgive me while I check my notes. Yeah, I think, let me just turn and take instructions. I'm most grateful. I'm most grateful for the extra 5 minutes, which is beyond my allowance.
Very good. All right. Well, thank you very much. We're very grateful to all of you, those who have spoken and those who have not. We will reserve judgment. It will be provided to you in draft when it's ready. It'll be provided to those whose contact details have been provided, and that will be subject to the embargo, which I know that all counsellors' solicitors will know about and will explain carefully to anybody else who needs to understand it. We hope and expect that in the light of whatever we decide, you will be able to agree between you a draft order to reflect and give effect to our decision. If you are unable to do so, we will have short submissions in writing and resolve them without a further hearing. That concludes the hearing, so thank you again.